Again, thank you for having us. My name is Susan DeClerc, and I'm here with Sarah Karpinen. We are both Assistant United States Attorneys in Detroit, Michigan, in the Civil Rights Unit of our office. Next slide. So today we're going to be talking about a number of federal laws that our office enforces that protect veterans and service members from discrimination. Unfortunately, the sacrifices made by our nation's service members go beyond the courageous act of putting themselves into harm's way to defend our way of life. The sad fact is they also face obstacles to exercising their civil rights and maintaining their family's financial security. This is why the Justice Department has made it a priority to enforce the statutes specifically created to protect the rights of those serving or who have served in our armed forces. In going through the statutes, we'll focus on a few specific areas of life where discrimination can often arise. These will include the unique challenges that service members face while on active duty, the challenges veterans face when returning home, and the challenges that families face when a family member is deployed. Finally, we'll give you information on what to do and who to contact if you believe that you have suffered discrimination or if you are aware of someone who has. Next slide. So this is a little outline of what we're going to be talking about today. We're going to go through the background, and then we'll go into the law, and then we'll tell you about how to get help. Next slide. So before we get into the legal substance, we'll give you a little bit of information about our office specifically and what we do. The U.S. Attorney's offices are part of the United States Department of Justice. The current head of the Department of Justice is Loretta Lynch, who took over the position this year from then Attorney General Eric Holder. The Department of Justice is headquartered in Washington, D.C., and consists of dozens of different components, including investigatory agencies like the FBI, as well as litigating agencies like the U.S. Attorney's Office and the Civil Rights Division. There are 94 U.S. Attorney's offices across the United States and U.S. territories, with at least one in each state. We are like the local field offices of the department, and we work very closely with the Justice Department attorneys in Washington. Next slide. Here in Michigan, we have two U.S. Attorney's offices, one for the Eastern District of Michigan, which covers the eastern half of the Lower Peninsula, and one for the Western District of Michigan, which covers the western half of the Lower Peninsula, plus the entire Upper Peninsula. Sarah and I work in the Eastern District, and our boss is United States Attorney Barbara McQuaid. She was appointed to the position by President Obama and confirmed by the Senate in 2009. Our office enforces federal laws throughout the Eastern District of Michigan. We prosecute criminal cases, bring civil actions, and defend the government in federal court on behalf of the United States. Next slide. Our main office is located in Detroit, but we have smaller offices in other cities where federal courts are located, including Flint, Bay City, Port Huron, and Ann Arbor. Our district serves approximately 6.5 million residents and covers 34 counties. Next slide. In 2010, our office became one of the first U.S. Attorney's offices in the country to officially establish a civil rights unit. Working closely with the Civil Rights Division in Washington, we investigate and litigate cases to enforce laws relating to civil rights matters such as fair housing, fair lending, disability rights, equality in education, voting, and many more, including today's topic, which is the civil rights laws specific to veterans and service members. Most of our cases come from complaints received by our office by community organizations or by individual members of the public. We have a telephone hotline as well as an email address specifically for complaints about possible civil rights violations. Next slide. So now let's talk about the substance. Today we'll be covering 4 specific statutes which make up the bulk of our service member veterans work. These are the Uniformed Services Employment and Reemployment Rights Act, also known as USERRA, the Service Members Civil Relief Act, also known as SCRA, the Uniformed and Overseas Citizen Absentee Voting Act, which is also called UOCAVA, and the Americans with Disabilities Act, or ADA. Sarah is going to start by talking about USERRA. Next slide.
Good afternoon, everyone. This is Sarah Karpinen. Thank you for taking the time to attend the webinar today.
I am going to, as Susan said, I'm going to discuss USERRA and give an overview and some examples of some cases that have been brought by the Justice Department under this law. The core principle of USERRA, which is to make sure that those who serve our country in uniform are not penalized in their civilian jobs because they served. No one should have to be overseas worrying about whether their job will be waiting for them when they come home, nor should they be losing out on promotions, raises, or benefits simply because they were away serving their country. The law is interpreted liberally in favor of the service member and has two key provisions. The first is an anti-discrimination, anti-retaliation provision, and the second places affirmative responsibilities on the part of employers to reemploy service members and bring them back to the job that they would have had they never left. USERRA applies to most employers regardless of size and also applies to the federal government and to state and municipal government. Next slide, please. I'd first just like to go briefly into the anti-discrimination provisions. The discrimination provisions go beyond just a decision not to hire someone or a decision to let them go, but it also applies to promotions and benefits. So an employer cannot discriminate against a veteran or a service member because he or she has served in the past, is serving in the present, or may have a future obligation to perform military service. And employers, so for an example, an employer can't deny someone a promotion because they may go off and perform guard duty. They can't terminate someone because they think that they may have absences in the future. If an individual's past, present, or future connection with the service is a motivating factor in an adverse employment action, the employer has violated USERRA unless the employer can prove it would have taken the same action regardless of the person's connection with the service. The burden will be on the employer under this law to prove that, not on the service member, so it's on the employer to prove that they would have done that anyway. In addition to being prohibited from discriminating against people on the basis of their service, employers are also prohibited from retaliating against anyone who files a complaint under USERRA, testifies, assists, or otherwise participates in an investigation or a proceeding under the law, or exercises any other right under the law. This provision is important because it applies to anyone, regardless of military service. So if a service member is overseas and a coworker who has never served in the military may overhear the employer saying, well, we're going to let go of that person because they're not reliable, they may have to get called back again. When they come back, we're going to let them go. That coworker can come forward without fear, maybe testify on behalf of the service member, assist with their case, and that person is also protected under USERRA. Next slide. The next key provision of USERRA is reemployment. An employer is obligated to reemploy a service member upon their return from duty, but both employer and employee have obligations in this area that they should be aware of. The employee must have left his or her job to perform uniform service. That's very broadly defined. People are covered if they're in voluntary service, involuntary service, active duty, training, full-time National Guard duty, even funeral honors duty performed by National Guard or Reserve members is covered, and even absence from work for examination to determine fitness for duty would be covered, among other things. So it's very broadly defined. The service member should, or the appropriate officer of their military branch should give notice to the employer, but there are exceptions. If there's an emergency that makes it impossible for them to alert their employer before they leave, or if it's otherwise impossible or unreasonable under the circumstance, then that lack of notice can be forgiven, and the notice can be oral or written. The other provision is that the individual can serve, it has to be 5 years or less of cumulative duty in order to be entitled to their job back, but there are also exceptions in that area. If there's involuntary active duty extension, called away for a war or a national emergency, or if you have an initial service obligation of more than 5 years, then that cumulative total does not apply, and you can have more than 5 years before you lose your reemployment rights. The next condition is that the service member has to have been released under honorable conditions, and so anybody with a dishonorable or a bad conduct discharge is not covered by USERRA. Finally, there's time limits. You have only a certain amount of time to reapply for your job, and
basically, not surprisingly, the longer you're away, the more time you have to report back to your civilian employment. If you've served less than 31 days, you must report back to your civilian duty at the beginning of your next regularly scheduled workday following your release from service, plus the expiration of 8 hours after a time for safe transportation. So time to get back, sleep, and then go back to work. But if you serve more than 30 days, but less than 181 days, you would have 14 days to apply for reemployment upon your release. And if you serve for more than 180 days, then you have 90 days to report back to work. It's important to note that if a service member is injured or becomes ill in the line of duty, then they may have up to 2 years to report back while they're recovering or in the hospital. And finally, the employer does have a right to request documentation from the service member to show the length of the service, maybe to show what the cumulative total of the absence was, and whether or not their separation was disqualifying or not. There's a right to request some documentation. Next slide. All right, the next slide, this deals with the terms of the reemployment. So if you're overseas serving your country and you were an account manager, they can't offer you back at a much lower position when you return. They have to offer you a similar job and with a similar seniority rank, status, and pay, and you have to get your rights and benefits as determined by seniority back as you had them, or as you would have had them if you had never left. The questions may arise if your circumstances have changed while you're away. For example, you're injured in the line of duty. You may not be able to perform the work that you were doing when you left. If you have become injured and are disabled when you return, your employer is required to make reasonable efforts to accommodate you. And as I've noted before, you'd also have up to 2 years to get back to health before having to report back to duty. Now, another thing that may come up is if you had a job that had a license or a certification requirement that may have expired while you were serving overseas or serving even stateside, the employer has to make reasonable efforts to enable you to return to work. So this may be to put you in an alternate job for a short time period while you get your certification back, or just some type of accommodation to give you that time to get back to where you would have been had you not left. The employer may have some defense to USERRA if their business has changed so much that maybe they have almost no employees left, or they're completely retooled and they're in a different business by the time you come back. So that there are some defenses on the employer's behalf. However, again, the employer would have the burden to prove that those circumstances exist. Next slide. All right, our next slide deals with seniority, wages, and benefits. And this just deals with what terms and conditions of employment that a service member would have when they return. The most important thing to remember is that there's an escalator principle. So if by seniority or by another means you would have been promoted, brought up higher on the pay scale, something similar, well, if you had worked while you were serving, then you are to be offered that position when you return. You should be able to maintain your health care benefits for up to 24 months while you're serving, although you may have to pay premiums during that time period. And your pension, you should be, again, treated as if you had never left, and that you didn't have a break in service for purposes of your participation, vesting, and accrual of your benefits. If the service member is enrolled in a contributory plan, such as a 401k, the service member is allowed but not required to make up any missing contributions to the plan and then receive matching funds if the employer offers those. And service members also must be permitted to use any of their accrued vacation time, but they can't be required to use that for their military leave. Next slide.
Hey, Sarah, we have a question from the group. Would you like to take that now, or would you like to wait until the end?
I guess we can take that now. This law, like other employment laws, overcomes an at-will statute. So if Michigan, just because Michigan is at-will, an employer may be at-will, the service member, when they return, that's no longer an at-will employment. So if you can show that because they were terminated, they were not offered a job because of their service, then that would be an exception to any at-will principles that apply in any state.
All right, thank you.
I'd also like to, all right, so For the next slide, slide 14, the non-seniority-based benefits. This is anything that wouldn't be granted to somebody by seniority, and the basic principle with that is that you are entitled to anything that somebody on any other type of furlough or leave of absence would get. So if somebody were to go off on for example, a maternity leave, and they'd be entitled to holiday pay while they're off on leave, the service member should get that as well. So anything that's not seniority-based should go to the service member if other people can get it while on a leave of absence or a furlough. So you may not be entitled to any special privileges in the non-seniority benefit category, but you should be treated the same as any other employee. Next slide.
Oh, Sarah, we have one more question.
Oh, there is an exception. The question is, how would USERRA apply to an individual who was hired but had yet to have their first day of employment? And there is an exception if the employer can show, look, this person only maybe worked here for a day, or I hired them for some type of a temporary employment, and now they're coming back and saying they have the right to this job. The burden would be on the employer, but an employer can show that this person had no expectation of continued employment. But again, I guess it could be a case, I would just guessing, if somebody had their first day of employment, was called to service, but had an expectation just like someone else that that job was to continue, then they may be able to establish that they are entitled to that job back. But that would be something an employer could definitely raise as a defense to a USERRA claim.
Great.
All right, and now I'm just going to do some recent cases that illustrate some of the principles that we've gone over that have either been brought by the Justice Department nationally or by our office or the Western District. The first one is the Bullhead City Fire District, and in that case, the service member was deployed 3 times in the Army Reserve while working in the fire department. And while he was on his second deployment, his supervisor made negative statements about his service, but then he went off on his third deployment, and his position was eliminated, and the employer refused to reemploy him when he came back. But the department continued to have other people doing his job duties. They continued to post new job openings. So that case was brought and was settled for back and front pay, and the department updated its policies accordingly. The Penske truck leasing case, that one is one where the service member did suffer a service-related injury while away, tried to return to work but said he had some limitations. The employer said that they could not accommodate him and put him on a short-term leave. He then asked for some more time to get back to a position where he could take his job back, and the employer terminated him. And that was another case that resulted in a settlement. The third case is the Cerricchio versus Wachovia, and this one stands for the principle that the employer does have to give you some time to get your certification back, and also that they have to promptly reemploy you. This case involved a financial advisor. He was an Air Force reservist, and he was called to active duty after September 11th. When he tried to come back to work, the employer first waited 4 months to reinstate him, then offered him a position that didn't take into account even where he'd been at the time he left, let alone where he would have been had he never left. And he no longer had a broker's license because it had lapsed, and the employer was ordered to reinstate him and also to give him a fixed salary, which it didn't normally pay. It paid people in his classification so that he could get his broker's license back. Next slide. And the final 2 cases I'm going to discuss, these are Michigan cases. The first was the Highland Park Fire Department. And in this case, a reservist was working at the fire department as a part-time employee. And to get a full-time position, it was based on seniority. And while he was overseas doing his duty, 3 firefighters with less seniority than he had were promoted to full-time, but he was denied the same promotion. So that case was settled to give him that promotion because he should have been treated as if he had been there and been in line for that promotion along with the other employees. And finally, the equity case, that was a case in the Western District, and this was a reservist who was away for only 4 weeks and was terminated for excessive absences. So that case was resolved by the Western District. Next slide. Okay, and then the next slide, it just gives you the information about how to file a complaint. The complaints would go through the Department of Labor, and that's the contact information for the Department of Labor on the slide. If they're unable to resolve it, it can be referred to the DOJ for litigation. And there's also some good information available at servicemembers.gov. That's a DOJ website, and that would cover not only USERRA, but a lot of the laws we're talking about today. All right, and I will give it back to Susan, who's going to discuss the Servicemembers Civil Relief Act next.
Sure. The Servicemembers Civil Relief Act was formerly known as the Soldiers and Sailors Civil Relief Act. It is a federal law that provides a wide range of relief and protections for military members while they are on active duty or as they are just about to go on to active duty. The law's purpose is to postpone or suspend certain civil obligations so that the members of the armed forces can focus their full attention on their military responsibility without adverse consequences for them or their family while they're gone. It covers a wide variety of issues such as rental housing obligations, interest rates, and protection against certain judicial proceedings. So, for example, the SCRA requires lenders to reduce any interest rate on a service member's existing credit card, student loans, car loans, or mortgages to 6%. Now, interest rates being what they are recently, that may not seem so great, but you know, in years past, that has actually been a substantial reduction. And the lenders must do this reduction as soon as the service member notifies them that they are being deployed. SCRA also allows service members to prematurely end their car leases or their residential rental agreements. So if a service member is unexpectedly called up and has to deploy quickly, he or she should not have to be saddled with the extra money that they would have to pay on an apartment or a car that they can no longer use. The SCRA also prohibits foreclosures on mortgages or evictions from rental houses without a court order, and it prohibits any default judgment from being entered against an active service member unless a specific official military affidavit is provided. There's also a prohibition against enforcement of storage liens without court order to prevent the service members from losing their personal property while deployed. You know, all of these are really meant to make sure that civil proceedings are not going on back at home while the service member might be deployed overseas, where they might not be getting the appropriate notifications and things like that. The United States has successfully enforced the SCRA all over the country. Next slide, I think. So, for example, the Department of Justice investigated Navient, which is formerly a part of Sallie Mae, for overcharging service members on their student loans. As a result of that settlement, 770,000 service members will receive they'll share in $60 million in compensation. In San Diego, where they have a very large active military community, the Justice Department brought a case against a storage company, and the storage company had to pay $170,000 for unlawfully selling the service members' belongings while they were deployed. Next slide. We also have some mortgage providers where the Department of Justice settled a case against a number of very large mortgage providers for illegally foreclosing on service members' homes while they were away on deployment. The case was settled for $123 million in awards to the individual service members, as well as a large monetary award to the United States. Here in Michigan, we actually have a really unusual case where a landlord was criminally convicted for unlawfully evicting a service member's family while he was deployed. I think these are particularly unusual circumstances, and it has really egregious facts where the landlord evicted a service member's pregnant wife and children while he was away for only being 12 days late on their rent. So that was a little bit crazy, but these things actually do happen. Next slide. So again, here is a point of contact. If a service member if any of these things occur to a service member while they're deployed, or they need assistance with figuring out how to do these, in advance of being deployed, the service member should contact the Armed Forces Legal Assistance Program. We've put the website up here where they can find the nearest program. That particular agency they will investigate the complaint, and then if they're unable to resolve it, they can refer it to the Department of Justice, and then that's where we would get involved. Next slide. Okay, and now Sarah's going to talk about UOCAVA and voting rights.
I'm back. I'm just going to briefly go over the UOCAVA, which is the Uniformed and Overseas Citizens Absentee Voting Act. And our division enforces this law, which has been amended by the Military and Overseas Voter Empowerment Act, which is also known as the MOVE Act of 2009. And the purpose of these laws is to give military and overseas voters a meaningful opportunity to register and vote absentee in elections for federal office. What this means is service members should not be denied the right to vote because they're overseas serving their country, and nor should other citizens or their family members that are also living outside the borders of the United States. The law would apply to members of the uniformed services and to the merchant marine, their family members, and any United States citizens residing outside the United States. The Secretary of Defense has primary responsibility for implementing UOCAVA, and the Attorney General and the Department of Justice may bring a civil action in the appropriate district court to enforce it. This duty has been assigned to the Civil Rights Division, which is why we're discussing it here today. Next slide. This is just a basic flow chart of how UOCAVA works. Basically, it provides for an application called the Federal Postcard Application. Qualified service members and overseas citizens can fill that out to register to vote and request an absentee ballot at the same time. And it's supposed to go to your local election official. They should review it and then send you an absentee ballot that you would then return and have your vote counted. However, because that doesn't always happen, there is a backup ballot for federal offices called the Federal Write-In Absentee Ballot. And this ballot can be cast if someone makes a timely application for a regular ballot, but does not receive it timely. The MOVE Act, which was passed in 2009, amended UOCAVA to establish new voter registration and absentee ballot procedures, which states must follow in all federal elections. Most of these were implemented by November 2010, and the Justice Department has been filing suit against states that have not complied with the law. The MOVE Act amends UOCAVA to ensure that voters have an option to request and receive voter registration and absentee ballot applications electronically, that they should be receiving validly requested absentee ballots no later than 45 days before an election for federal office, unless the state has requested and received a waiver from the Department of Defense for undue hardship. And states are also required to take steps to secure the security of the voting process, the balloting, the privacy of and the identity of the voters. And states are also to accept federal write-in absentee ballots, and those are the ballots that you would send out if you are unable to receive a regular ballot. Those are to be accepted in all elections for federal office beginning December 31st, 2010. And UOCAVA voters are also supposed to be able to track the receipt of their absentee ballots through a free access system. Next slide. I'm just going to note a couple of examples of cases that I think I noted earlier that states can request a waiver. In 2014, West Virginia tried to get a waiver for getting ballots out 45 days before the election, and that was denied. So the DOJ ended up filing suit to obtain compliance with the law for West Virginia voters. And in Michigan, a complaint was filed alleging that the state of Michigan failed to transmit absentee ballots to UOCAVA voters timely before an August 7th primary election that year. And that case was resolved with a stipulated order which gave those voters a longer time to submit their ballots in that election. And the DOJ just doesn't only file suit in these cases, it also plays a role in just contacting states trying to make sure that they're aware of their obligations and obtain a voluntary compliance with the law. And I think I think I had the contact information for the Federal Voting Assistance Program on the first slide. But if you can go to fvap.gov, and I think that's on the first slide if you want more information. It shows copies of the ballots and so on. That's my brief overview, and I'd like to send it back to Susan for coverage of the Americans with Disabilities Act.
Okay. So finally, we have the Americans with Disabilities Act, also known as the ADA. It was enacted in 1993 and was recently amended in 2010. It is a very wide-sweeping law designed to eliminate discrimination on the basis of disability and to ensure the integration and inclusion of individuals with disabilities in really all aspects of American life. It is not a statute that is specific to service members or veterans, but given that many in the military are injured or can incur disability as a result of their service, the ADA, we figured that the ADA was an important statute to discuss here. The ADA has a number of different provisions, but in a nutshell, it prohibits discrimination in employment, it mandates that buildings be physically accessible, and it requires businesses to take reasonable steps to ensure that people with disabilities have equal access to their goods or services. One important limitation to the law, however, is that it does not apply to religious institutions such as churches or synagogues or religious schools. Next slide, please. So with respect to employment, the ADA applies to all state and local governments and private employers with more than 15 employees. It applies also to all employment practices, including hiring, promotion, compensation, benefits, etc. Substantively, the ADA prohibits employers from discriminating on the basis of disability. It prohibits any harassment based on disability, including by coworkers. It prohibits retaliation against employees for exercising their rights under the ADA. And most importantly, it requires employers to provide reasonable accommodation. Under the ADA, a reasonable accommodation is a change in the job environment or in the performance of the duties of the job that are necessary to enable a qualified individual with a disability to perform the essential functions of the job. Also, it must be reasonable. That means the size and the resources of the particular employer must be considered. Some reasonable accommodations are typically changes to the workplace, physical changes to the workplace, such as installing a ramp or moving an employee to a different cubicle. Others are acquiring or modifying specific equipment that an employee may need, such as special communication software, or even just providing a back pad for their office chair if they have some back problems. A reasonable accommodation can also be, though, allowing an employee to change his or her work schedule or to be given additional time off if they need to go to medical appointments or can only work for shorter periods of time. However, it's important to remember that any of the accommodation cannot interfere with the essential functions of the job. USERRA, which you've already heard about from Sarah, also provides protection for employees, but there are some important differences between USERRA and the ADA. USERRA actually requires employers to go further to assist their employees than the ADA does. Again, with that is because of the importance of assisting and protecting those who do military service. There's also an important difference between who qualifies as disabled under USERRA and who qualifies as disabled under the ADA. So whenever there is a service member having a problem at work, it's important to consider both of these different laws. Next slide. The ADA also mandates that public accommodations be accessible. This, of course, means that buildings and public spaces must be physically accessible, such as having ramps into buildings or providing designated accessible parking spots. The ADA regulations themselves provide very specific details about accessible design standards, and the level to which a building must comply with the standards depends mostly upon when the building was constructed relative to the enactment of the ADA. So, for example, new construction, it must comply entirely to the standards. but older buildings or historic buildings that were in existence prior to the ADA, it's a much lower standard, and they really need to make their building accessible, and they must do anything that is what's called readily achievable. And then there's also like a middle ground as well. But the ADA also requires that public entities modify their standard policies and practices to allow people with disabilities to have equal access. This is also part of the accessibility concept. This often comes up in the context where an entity has a facially neutral policy, but that facially neutral policy adversely affects people with disabilities. So for example, the perfect example of this actually are service animals. Many businesses have policies prohibiting animals on their premises, especially restaurants and hotels. But this policy adversely affects people who have disabilities and require the use of a service animal. So the ADA requires that the entity must make reasonable modifications to their existing policies to allow the animals to come onto their premises. Similarly, the ADA requires that entities communicate effectively with individuals with vision, hearing, and speech disabilities so that they will have access to their services and goods. The public entities are required under the ADA to provide the tools or services that are needed for effective communication, not the individual with the disability themselves. So for example, a hospital should provide a sign language interpreter for patients who are deaf. They cannot require that the patient bring their own interpreter or charge the patient for hiring one on their behalf. Next slide, please. Our office handles a lot of ADA cases. The ADA actually makes up probably the majority of the work that we do here. And we listed a few of them here, and I'll only talk about a couple of them in the interest of time. So, for example, we've had cases where we've required large entertainment venues, such as the Palace of Auburn Hills and VT Energy Theater, to extensively renovate their arenas to make them more accessible and to provide accessible seating. We've had cases against cab companies who have refused to pick up people with service animals. And in the employment realm, we very recently settled a big employment case with the University of Michigan for failing to reasonably accommodate an employee with a disability by transferring her to a vacant position when, as a result of her disability, she was no longer able to perform the essential functions of her current position. Next slide. So basically, this is how to contact us. I know that we've given you information about other agencies to contact with respect to specific statutes, but when in doubt, if you believe that any of these rights have been violated, or you're aware of any situation that you think might fall within any of the laws that we've discussed today, please contact us. You can contact us by phone or by email, and even if we can't help you, or even if you have to go to another agency first, we can direct you to that, or we can put you in contact with someone who can help you out. I think that is pretty much the end of our prepared presentation, and I know that we've given you a lot of information today, and we really only scratched the surface of the details of these particular statutes. But so if you have any questions, we'd be happy to answer them now, or again, if you think of them later, you can feel free to contact us directly.